If you've watched parts 1 and 2 of this talk, you know that the goal is complete and total bodily autonomy for women. The solution is the courts establishing the specific legal status as to whether the fetus is a person or not, and that status doesn't really make much difference. Because under current law, if the fetus is legally a person, the woman gets to choose what happens with her pregnancy. And if it's not legally a person, the woman gets to choose what happens with her pregnancy. The only way she doesn't get to make that choice is if our courts and institutions are playing fast and loose with the laws in that fuzzy, indistinct middle, which is just what they're doing. So, what is the strategy that would get the courts to make this clear distinction? In the 165-year history that the abortion rights issue has existed in this country, only one type of strategy has addressed it at the national level. And it hasn't been federal laws, policies, or amendments, presidential declarations, or executive orders. The one type of strategy has been a legal one in the form of Roe v. Wade. And that's what this strategy is, a legal one, and can be used in any state that restricts access to abortion procedures, whether it's Texas or California, Alabama or New York. If it restricts access to abortion procedures, this strategy can be used. And it comes in the form of a constitutional challenge to the state's ability to deny access of safe approved legal treatment for a group's medical condition. Again, a constitutional challenge to the state's ability to deny access to safe approved legal treatment for a group's medical condition. It would go something like this. A group, organization, or its members would go to court and say that their 14th Amendment right against discrimination is being violated by state laws that are denying them access to safe approved legal treatment for their unique condition. And that's what the states are doing, discriminating. They're not denying access of treatment for any other group's medical condition. They're not restricting the safe approved treatments for those conditions. Just this one group and this one treatment. The very definition of discrimination. So the courts take up this 14th Amendment challenge, and the states have to explain why they can discriminate against this one group of people. And given the group and the procedure, there's only one reason, the one that the courts have always given them. Recognize interest in prenatal life. Now, once the states give that reason, it can be challenged. The court can be asked whether this prenatal life has rights or protections that allow a state to definitively and consistently discriminate against this group of people. Once the courts make a determination, the distinction as to whether or not this prenatal life has rights or not, the solution kicks in. And whichever the decision, the woman gets to choose what happens with her pregnancy. And this all applies under current law. What's happened is the strategy has led to the solution leads to the goal. But what if the states have this ability, that they can deny access to safe approved treatment for a group? This is one of the other things that Dobbs has done that no one is talking about. It has, in effect, given the states this power so that the states could deny access of treatment for Tay-Sachs, for Jewish people, treatment for sickle cell anemia for Black people, HIV and transgender medications, geriatric treatments and procedures for seniors. In fact, the states could deny medical treatment for any group it chooses. We would, in effect, be back to where Black people could be denied medical care in white hospitals, a resurrection and expansion of Jim Crow. This is one of the dangerous things that Dobbs has also done. So why this roundabout strategy? Why not go directly to challenging fetal rights? And the answer to that question is that, well, technically, that's not what the courts in the states are doing. That's the effect, but that's not what they're doing. What they will say is that they are not applying rights to the fetus. They are allowing the states to restrict and regulate a medical procedure. So what the strategy is doing is going to that reasoning. But it does bring up a statement that is often made, that abortion is not a constitutional right. And if you take that attitude, then setting bones is not a constitutional right. Vaccines are not a constitutional right. Any prescription medications are not a constitutional right. In fact, no medical care or treatment is a constitutional right. But that's not what we believe. We believe that if we need medical care and that it is available, we should have access to it. It's a part of our inalienable rights, life, liberty, pursuit of happiness, or our enumerated rights, like the right to privacy. The procedure for terminating a pregnancy has saved lives. So, to the question, is abortion a constitutional right? It's as much one as any other medical procedure and shouldn't be restricted any more than any other medical procedure. And that is usually for the safety of the patient. Now, to explore one last thing, and that is the reasons that the courts give that allow states to intervene in a woman's pregnancy. Recognize interest in prenatal life. When you think about that statement legally, it doesn't make much sense. Prenatal life has no rights, not a person. So you just as easily could say that the state has a recognized interest in your kidney or your left leg or your right arm. The word interest is vague and can be interpreted broadly, especially without the trimester guidelines, and that's what the states are doing. Recognized interest, recognized by what? What law? What does recognized interest even mean? The word recognized itself is vague and can be interpreted broadly. The statement recognized interest in prenatal life can be seen as something that the Roe courts made up to allow states to intervene in the pregnancy so that they could craft a compromise acceptable to the public. In any case, this reasoning, if it hasn't been directly challenged in the courts, needs to be. So, a synopsis of the strategy as to how to get the courts to make a distinction between whether the fetus is a person or not begins with a constitutional challenge to the state's ability to deny access to safe, approved legal treatment for a group's medical condition, a violation of the 14th Amendment against discrimination. Once the states give the reason, recognize interest in prenatal life, that can be challenged. Does the prenatal life have rights? When the courts make that determination, the solution kicks in, and whichever way that goes, the woman gets to choose what happens with her pregnancy. The strategy leads to the solution leads to the goal. And now a quick outline to this approach for addressing the abortion and reproductive rights issue under current law. It comes in 3 sections. 1, complete and total bodily autonomy, the goal. No compromise. 2, the solution. A courts need to be made to establish the specific constitutional legal status of the fetus, whether it is legally a person or not. Goes to constitutional rights. 3, the strategy for getting the courts to make that distinction is a constitutional challenge to the state's ability to deny access of safe, approved legal treatment for a group's medical condition, a 14th Amendment violation against discrimination. A subsequent challenge to the state's recognized interest in prenatal life, whether that life has rights. Once again, the strategy leads to the solution leads to the goal. Share the strategy. Thank you for watching.